Yes, Mr. Kelvin.
Good morning, my lord. May it please your lordships, my lady. These are two appeals to be heard together, and I appear on behalf of both the appellants in the appeals. My learned friend, Mr. Peacock, appears on behalf of Westminster City Council, the City of Westminster, in the Hajjaj appeal, and my learned friends, Mr. Grundy of Queen's Counsel, leading Mr. Mullen, appear on behalf of the London Borough of Waltham Forest in the Akhter appeal. My lord, it's agreed between my friends that Mr. Peacock will take a lead on the common ground of appeal, not dealing with the Article 3 point.
Yes.
And Mr. Grundy of Queen's QC will then follow, dealing with matters that he wishes to raise just following on from that, and then dealing with the separate ground of appeal, Section 208 ground of appeal, dealing with procurement and out-of-district placement, which is a standalone ground of appeal in the Akhter appeal.
Yes.
My lord, my lady, should have the core bundle and supplementary bundle in relation to both appeals, and a joint bundle of authorities to deal with the issues arising in this appeal. I've handed up a copy of the current 2012 order. I apologise to the court for including an order that just before predates the order that now I've handed up. It alters not the substance of the order, but my lords, in my skeleton argument, I repeat and rely on the correct version of the Article 3, just so that the court has that, and it can be inserted at tab 11. The old order can be removed if that would assist at this stage.
It's quoted
It is.
It's
quoted by
Mr. Peacock's
Indeed.
skeleton argument. Is that the correct text?
That is the correct one, and it's quoted in my skeleton argument as well. So I'm a learned friend, friends for the local authority. My lord, just finally, by way of introduction, the legal aid agency reinstated the public funding for Ms. Akhter on Friday.
Good.
That was before the decision of the court to proceed in any event, but thankfully the agency have reinstated the funding for Ms. Akhter, so we can proceed. I can proceed in relation to both appeals. My lords, can I deal with the common ground of appeal? And the issue is in what circumstances, or what is required before a local authority can approve a private rented sector offer for the purposes of Section 193, subsection 7F of the 96th Act. Can I ask my lords and lady to turn in the bundle of authorities to tab 10, and we go to the Section 193 and spend a bit of time just to explore the concept of private rented sector offers.
Mr. Cover, my version of the authorities bundle doesn't have tabs, so could you give us page numbers as well?
Page 189, my lord.
I'm obliged, thank you.
If it's just Section 193, I was intending to use the skeleton argument because it's easier to
Indeed.
Draw on, so to speak.
I will take, just for reference, to other sections, just for context. But 193 is the principal section that the court needs to consider. We can see, just by way of preamble, in subsection 2, it's what's called the main housing duty, and it is where the authority accept that a person is an applicant, is eligible for assistance, is homeless, in priority need, and not intentionally homeless, that the duty that we can see at subsection 2 arises, and that is that unless they've made a referral, which in this case we don't need to worry about that, but there is scope within the Act for referrals to be made to other authorities to discharge the duty, they shall secure that accommodation is available for the occupation by the applicant. So that is the main housing duty. The accommodation that has to be provided has to be suitable. You can find that in section 206, just for the court's reference. I don't need to take your lordships, my lady, to that unless it would assist. but the accommodation must be suitable. And there is no definition of suitability within the Act, matter for the local authority, but Section 210 does provide that there are certain matters that must be taken into account when assessing suitability, and the Act requires in subsection 1 of Section 210 the regard to have to some clearance provisions and overcrowding provisions in the 1985 Housing Act and the 2004 Housing Act. We don't need to deal with those because that doesn't arise in this case, but subsection 2 does give the power for the Secretary of State to make an order specifying the circumstances in which accommodation is or is not to be regarded as suitable for a person. So the Parliament has given the power to the Secretary of State to step in and to make orders specifying what accommodation may be or is not to be regarded as suitable. We'll come back to the exercise of that power in a moment, but going back to Section 193, it is settled law now, following this court's decision in the case of Griffiths, that the 1932 duty, the main housing duty, can only come to an end when the circumstances set out in the Act occur. So, and those we can see are in subsections 5 through to subsection 8 in the Act, and they set out various ways in which the duty comes to an end. And until such occasion arises, the main housing duty continues and would continue if, for example, the accommodation that's occupied comes to an end, the duty hasn't come to an end, the local authority would have to continue to provide alternative accommodation, which is suitable. And that duty continues until, as I say, until such time as the Act, the criteria within the relevant subsection is satisfied and the duty comes to an end. Now,
that's what 1933 says, doesn't it?
It does. Indeed. Yeah. My Lord's quite right. And on the 9th of November 2012, the Parliament extended the use of the private sector housing to discharge the 1932 duty, the main housing duty. And prior to that, the only way in which the private sector could be used is the provision of an assured tenancy, non-short hold, so greater security being provided, and there was an acceptance of that assured tenancy by the applicant. That's subsection 6, little cc. So there was a limited use, and what Parliament introduced on the 9th of November 2012 through the Localism Act, they extended the use, and we can see that extension at subsection 7, capital A, in page 190 in the authorities bundle, and that provides that the authority shall cease to be subject to the duty under this section if the applicant, having been informed in writing of the matters mentioned in subsection B, 7AB, accepts or rejects a private rented sector offer. So the use of a question then is, what is a private rented sector offer, and that we can find in subsection 7AC. For the purposes of this section, an offer is a private rented sector offer, a PRSO, if it is an offer of an assured short hold tenancy made by a private landlord to the applicant in relation to accommodation which is or may become available to the applicant's occupation. Secondly, that offer is made with the approval of the local authority, pursuant to an arrangement between that authority and the private landlord, with a view to bringing the duty to an end. And then thirdly, the tenancy that is being offered, the assured short hold tenancy, must be a fixed term tenancy for a period of at least 12 months. So it has to be a 12-month plus tenancy, assured short hold tenancy. So the local authority, a PRSO can only be where there's an offer from a landlord to the tenant. That offer of the assured short hold tenancy is approved by the authority pursuant to an arrangement that has been made between the landlord and the private landlord with a view to bringing the duty to an end. If we can then move to subsection 7F, and we can see there that in respect of the approval, the local authority shall not approve a PRSO, little ab, unless they're satisfied the accommodation is suitable for the applicant and that subsection 8 does not apply to the applicant. So therein the Parliament have introduced the requirement that any accommodation must first be determined by the authority to be suitable before it can be approved for the purposes of subsection 7AC little b. What the even if it is approved, even if the accommodation is suitable under 7F, the subsection 8 requires the authority to consider whether or not the applicant is currently under a contractual obligation where they're currently staying in discharge of the duty, and that the applicant must be able to bring those obligations to an end before being required to take up the offer. So the applicant must be free to be able to take up the offer. And if he's not free to be able to take up the offer, then it follows that the accommodation can't be approved. It follows from that, looking through those subsections, that firstly, accommodation in the private sector can be offered on a 12-month assured short hold tenancy at a minimum by a private landlord if the authority consider it to be suitable, the accommodation to be suitable. That's the first step in the sequence that has to be followed. If the accommodation is if the accommodation is not suitable in the view of the authority, then the local authority can't approve the offer. If the accommodation is suitable, then they have to consider whether or not there are any contractual obligations preventing the acceptance of the offer. And if both suitable and there are no such obligations, then the local authority must approve it before the offer is made. If the offer is then approved by the local authority, provided the landlord can make the offer of accommodation, then he can make that offer of accommodation available on the 12-month assured short hold tenancy to the applicant. That's the first time that the applicant will be aware of the offer. He has no involvement in the process, no engagement in the approval or indeed the assessment of suitability. The offer is then made to the applicant, and then following on from subsection 7AA, he has either to accept it or reject it, but he must be notified that if he rejects it, the duty comes to an end, as does the duty come to an end if he accepts it. So he is notified of the consequences of this being a PRSO and the effect it has on his duty. That's how in my submission, how the Act is to be construed in terms of the process of making a PRSO. And stepping right back to the beginning, the first step, namely assessing suitability. As I indicated earlier, the Secretary of State has the power under section 210 to specify in an order the circumstances in which accommodation is or is not to be regarded as suitable for a person. And under that power, the Secretary of State made the Homelessness, Suitability of Accommodation England Order 2012. And that is the order that my lords will have at tab 11. Can I take your lordships, my lady, to that in the authorities bundle? And my lord, my lady will see the order. Article 1 commences on the 9th of November 2012. Article 2 sets out matters to be taken into account when determining suitability of accommodation in relation to location and disruption and so on and so forth, to matters that are relevant that need to be taken into account when assessing suitability in the context of the applicant and the applicant's circumstances. Article 3, which is the relevant article for this common ground of appeal, is to requires the local authority to consider the circumstances in which accommodation is not to be regarded as suitable for a person. And what Article 3 2, for the purposes mentioned in paragraph 2, in Article 3, paragraph 2, the purposes include, as Lordship and my lady will see on page 208A, the purposes determining according to 1937F whether a housing authority may approve a private rented sector offer. So Article 3, para 1 is engaged for the purposes of assessing whether or not the accommodation is suitable. And for the purpose, the accommodation should not be regarded as suitable where one of or more of the following apply. And then we have 10 instances where accommodation is deemed to be not suitable and therefore cannot be approved, and therefore the accommodation, the offer, cannot be a PRSO because it is not suitable. The 10 instances fall into 3 categories. The first category is those instances where the local authority are of the view that, those are the words taken from the subparagraph A to E. They are of the view that the accommodation is not unreasonable for physical condition. They are of the view that the accommodation doesn't meet the requirements of the electrical equipment safety regulation, of the view that the landlord has not taken reasonable fire safety precautions. They're of the view that the landlord has not taken precautions relating to carbon monoxide poisoning, and they are of the view that the landlord is not a fit and proper person. Then we have the second, as I would call it, second category, and that is where where, as a matter of fact, the accommodation is either licensed or it has the necessary certificates that are required. Those are dealt with in subparagraphs F to I. Licensing under the, if it's an HMO that needs to be licensed, that the necessary license is in place. In respect of additional licensing, that if that has been, if the authority have adopted additional licensing scheme, then that property must have the additional license. The accommodation has to have a valid energy performance certificate and a current gas safety record. So those are math questions of fact, not a question of view, but a question of fact. And then the third category is only one element to that, and that is the question of the tenancy agreement itself. What the Secretary of State requires is that the local authority it should be provided with a copy of the written tenancy agreement which the landlord proposes to use. So as part of this arrangement between the landlord and the local authority, the arrangement should be that we need to see the tenancy agreement we propose to use, so to make sure that it is a tenancy agreement we would approve, and which the local authority, using the words of subparagraph J, the local authority consider that agreement, having been given the proposed agreement, they consider it to be adequate. So those are the three, I would class three distinct areas, instances, where local authority must address in order to assess whether the accommodation is suitable. And we can see from the beginning, at the beginning of Article 1, paragraph 1, Article 3, paragraph 1, that where one or more of those instances apply, so it only takes one of those to not be satisfied, then the accommodation is not suitable in the language of the Act, the order, and therefore, if it's not suitable, it cannot be a PRSO for the purposes of the statutory provision. What the 10 instances in para 1 set out and identify are the requirements that any accommodation that is being provided from the private sector, what they must meet, the standards they must meet. They are requirements that must be satisfied in order for the accommodation to be suitable. So, for example, the accommodation must be in a reasonable physical condition. The accommodation must meet the requirements of the electrical equipment safety regulations. The landlord must have taken reasonable fire safety precautions with the accommodation. The landlord must have taken reasonable precautions to protect from the possibility of carbon monoxide poisoning. Go on and so forth. They set out the requirements that must be met, and each requirement must be met in order for the accommodation to be determined and defined to be suitable.
Mr. Colville, the submission you're facing is that the grammatical structure of this regulation doesn't say, as it could have done, accommodation shall only be suitable if it's in reasonable physical condition. Or even say, as it could have done, accommodation is only to be regarded as suitable if the local authority is satisfied that it's in reasonable physical condition. It's drafted in a very curious negative fashion.
My Lord, indeed, I accept that it's a curious form of wording. Can I take my Lord and the Court to the explanatory memorandum and then the Code of Guidance? Because I think that assists in assisting the Court as to how Article 3 is to be construed. Because it's not to be construed in my submission as giving latitude, which I know my learned friends seek to say that it does, namely that, well, in the absence of evidence to the contrary, they can assume compliance. In my submission, that drives a coach and horses through the whole article because of the way in which, because of the purpose and the intention of both the order and also the Code of Guidance in terms of the assistance. Maybe can I take my Lord to that, and then I will come back to my Lord's point because it's at the heart of the argument. My Lord, can I, in support of my submission that the 10 subparagraphs are in fact requirements. My Lord can see in the explanatory memorandum, it starts at page 210 of the Bible. This is the explanatory memorandum for this order. Just to pick it up in terms of context, what is being done and why, in paragraph 7.1 on page 211, the new power will allow local authorities to end the housing duty with offers of accommodation in the private sector without requiring the applicant's agreement to introduce as part of the government's wider social housing reforms, and to make better use of good quality private sector accommodation that can provide suitable accommodation for homeless households. And then in 7.2, the rationale behind the change to enable to effectively increase the fluidity within the housing sector and the discharge of housing duty using the private sector. Can I take your Lordships and my Lady to page 212, and the Court will see at paragraph 7.5 that during the passage of the Localism Act, there were concerns raised regarding the quality of the private sector accommodation. And in response to those concerns, the government decided that additional regulatory safeguards were necessary to prevent the use of poor quality accommodation for households owed the main housing duty, given some of the households may be vulnerable and offered accommodation over which they have less choice. To determine which factors would be effective in protecting vulnerable tenants, yet not place such a burden on the local authorities and landlords that no accommodation would be available, the government looked to existing landlord accreditation scheme across the country. 7.6. The government considered the common elements of those schemes, looking at how they operate, and developed a set of factors which, where one element was lacking, it would indicate poor quality accommodation. So what was intended was to introduce a regulatory safeguard to ensure that the accommodation that was going to be used as part of from the private sector, that accommodation would be at an acceptable standard of to discharge the duty, and to ensure that poor quality housing wasn't going to be used to bring the duty to an end in response to the concerns that were being raised. In the code of guidance that supports the which is a matter that's got to be taken into account by local authorities when dealing with issues of discharge of duty. If my lords and the lady could turn to page 130, and there's
just before we do that, Mr. Colville,
yes.
I think this is described as a statutory code. What's the authority under which it's issued?
My lord, it is a code that is issued, I believe, under section 182 of the Act. My lord doesn't have it in the bundle, but it's a code that the Secretary of State can issue to provide guidance to the local authorities on how they discharge, how they go about discharging the duties under Part 7 of the Housing Act. So, my lord, and page 130 sets out the guidance given by the Secretary of State dealing with the suitability of private rental sector accommodation, and repeats the...
Sorry, I think you mean page 216 of this bundle.
Sorry, I apologise. My lady's quite right. I apologise. Page 216.
This says archived on it.
It does.
Has it been replaced?
It's the code that was in place at the time when the decisions were made, but there's no change in the current code.
Right. When were the decisions made? What's the date?
The decisions were made on the 23rd of September 2020 and the 12th of October 2020.
Thank you.
The code, as I said, page 216, para 17.13. The code, the Secretary of State states that the private rented sector accommodation must meet the requirements of Article 3 if it is to be considered suitable when offered. So the Article 3 and subparagraphs A to J are seen as requirements to ensure that poor quality housing isn't used to discharge the duty. At 1715, the private rent must not be regarded as suitable if any of the following apply. And if I take the court to little e, that's dealing with subparagraph J in the order, dealing with dealing with the proposed written tenancy agreement that must be provided. The landlord has not provided a written tenancy agreement to the local authority which the landlord proposes to use for the purposes of a private rented sector offer and which the housing authority considers to be adequate. It is expected that the housing authority should review the tenancy agreement to ensure that it sets out, ideally in a clear and comprehensive way, the tenant's obligations, for example, a clear statement of the rent and other discharges and the responsibilities of the landlord that does not contain unfair or unreasonable terms such as call-out charges for repairs or professional cleaning at the end of the tenancy. So it's more that the language of the code is, in my submission, more than just a. It expects that the authority, one, receive the proposed written tenancy agreement, and two, considers that proposed tenancy agreement to ensure that the obligations within it are clear and not unfair or unreasonable in placing demands on that tenant. And that is what is required.
Well, we'll no doubt come back to this, but obviously the case against you on this subparagraph is that, of course, the language is mandatory, but asks Mr. Peacock, is it not sufficient for an established landlord like St Mungo's, if it has a standard tenancy agreement, to say that this will be on our standard terms, and there's no need for Westminster to ask to see the document every time?
If the question is to what extent assumptions can be made on the information that's before the authority, but the starting point must be that the proposed written tenancy agreement has to be made available to the local authority, and the local authority have to consider it. So it's not the language, indeed, and it ties in my submission with subparagraph J in terms of mandatory requirement that's imposed on the local authority for the purposes of protecting the tenant. In 17.17, over the page, on page 218 of the bundle, in determining whether accommodation meets the requirements set out in Article 3, housing authorities are advised to ensure it is visited by the local authority or someone acting on their behalf to carry out an inspection. Attention should be paid to signs of damp and mould and indications that the property would be cold, as well as to a visual check made of electrical installations and equipment, and looking at the details. So what is expected is that there is positive action taken by the authority under subparagraph A to ensure that the property is in a reasonable physical condition. So it follows, if I can come back to the point my Lord Justice Nugee raised, namely that it said against me that, well, the instance, for example, in little A is, well, if the authority are of the view that it isn't of a reasonable physical condition, then it's not suitable. But then, if there's no information to that effect, then they're not caught by Article 3. But Article 3 paragraph 1A, looking at the way the code and what the code advises, is that it's not if this eventuality arises, then it's unsuitable. The authority have to go and check and look at the physical condition to ensure that the property is in a reasonable physical condition in order to satisfy the requirements of Article 3.
Can I ask you two questions, Mr. Colville? Firstly, are local authorities under statutory obligations to follow a code of guidance of this sort? They
have to have regard.
They have to have, I suspected that. Could you give us at some stage the statutory provision which obliges them to have regard?
It's not in the bundle, but what I can do
It is in the bundle. 1821, section 1821, page 186 of the bundle.
Yes, indeed. My Lord's ahead of me. My Lord's page 186, section 1 of 182.
Thank you. And the other question was, what is the technical position now on whether a code of guidance can be used to construe earlier regulations? Because the regulations were issued in 2012 originally?
Yes, the order was made in 2012.
And the code you've shown us is dated from 2018.
Yes, indeed, my lord. It evolves over time, picking up different issues and addressing different issues. As far as this code is concerned, this is the guidance that had to have regard to.
One of the questions that we have to decide is what the interpretation of the regulations is. So to what extent can we rely on Code of Guidance issued in 2018?
My lord,
in construing regulations?
My lord, clearly it is the approach, this is the intention of the Secretary of State is that and indeed the intention of the government when making the order was in response to the consultation, the concerns raised through consultation exercise of the nature and the character of the property being used and to bring the duty to an end when dealing with vulnerable applicants. And this protection, Article 3 does provide a level of protection. And if it is the case that the Article 3 is to be construed as Article 3.1 is to be construed as providing not protection but eventualities of if the authority decides, it, in my submission, drives a coach and horses through the intention of the order to provide that regulatory framework, using the words explanatory memorandum, to protect the vulnerable applicant when presented with an assured short-hold tenancy in the private sector and told that if you don't accept it, our duty comes to an end. In my submission, my lord, to construe the order, the article, in the way that my friends contend it should be construed, means that local authority can close its eyes to the physical condition, the certificates, the license. It can close its eyes to what the tenancy agreement that's being offered, and make and say, well, because we do not know we have no information to the contrary, it follows therefore Article 3 is not engaged, or the circumstances in Article 3.1 do not arise, and therefore it is open to us to reach the decision that it's suitable. That, in my submission, defeats, I appreciate that's a strong word, but it does defeat the protection that the Secretary of State and the government intended to give to vulnerable homeless applicants who are owed the main housing duty.
I understand that entirely. Can we look at what the Secretary of State issued in 2018 to inform what the intention was in 2012
yes.
when the regulations were issued?
Yes.
And the answer is, you say is yes.
Yes. Yes.
Thank you.
Or I suppose you say alternatively that the Act, Section 1821, says that local authorities shall have regard to such guidance as may from time to time be given. Yes. So if there was a first edition of the Code of Guidance in 2012 or 2013, they had to have regard to that. And then when the 2018 edition comes out, they have to have regard to that. Yes.
My lord, my lady, the decision of suitability cannot be made in a vacuum. It has to be an informed decision. Subparagraph J requires the written tenancy agreement to be provided. That's quite clear on the language of the subparagraph. And the authority have to consider it to be adequate. My Lord Justice Bean made a fair point, namely that if it's a registered provider like St Mungo's using a standard agreement which has been seen before, then when we look at it must be right that the authority can say, well, we've already, are you using the same agreement as you used before, and which we have seen, and the answer is yes, then they don't need to see the agreement just for form, but they need to have made the inquiry to ensure that the agreement that that's going to be offered to the applicant, that agreement is the agreement they think is going to, is the standard agreement. So I'm not going as far as saying, well, we have to see, an applicant's entitled to see the agreement. The authority have to see the agreement if it's the same standard agreement that's been approved before, but they need to be told and informed that that is the proposed written agreement. Because then, if there's any questions, then they would be able to go back to the standard agreement they have on file and consider it.
When you were showing us section 193,
My lord,
section
yes.
193 7AC
Indeed, my lord.
B,
Yes.
top of page 191 of the
Indeed.
bundle,
My lord.
says that an offer is a private rented sector offer if it's made with the approval of the authority in pursuance of arrangements made by the authority with a landlord.
Yes.
That suggests that local authorities would enter into arrangements with someone like St Mungo. And one would expect those arrangements
To include.
to include
My lord.
what are the terms of a tenancy, requirements for the properties to be certified when required, requirements for them to be in good physical condition and so on. Do we have in this case any evidence of any arrangements made?
My lord, no. There's no evidence of the arrangement. What was the arrangement for the purposes of subsection 7 A, C, D? What we have, I'll take my lords and my lady to the actual offer letter once we get to the decision letter. But what we have is effectively an offer. It's been offered by St Mungo's and so on. So the arrangement, what little b requires is that there is an agreement or an arrangement, or however you want to describe it, between the local authority and the landlord. And that arrangement, in my submission, would include an agreement. If the landlord wants to use property A, that the agreement would be, the arrangement would be, but if you want to use property A, you must provide me with, and then set out a list reflecting the requirements of Article 3. So a detailed inspection report of the property.
Just pausing there then,
Ma'am,
you're saying that that arrangement might encompass not only provision of a standard tenancy agreement,
Yes.
which is what we were just talking about,
Yes.
but going further to say, in this case, St Mungo's have visited the property, can confirm the following. Is that
Yes, my
what
lady,
you have
that's
in mind?
that
That
might-
could be, are you suggesting that could be an appropriate arrangement?
my lord, my lady, I would say that's how the how the local authorities can avoid the onerous responsibility of doing the checks. They have to be satisfied that the property is in a reasonable physical condition, the necessary licenses are in place, the certificates, the EPC, the electrical, and so on and so forth. All the, in a sense, the desktop exercise that needs to be undertaken. That all that information is provided by the landlord, because it's the landlord who's going to benefit from the placement, because they have a tenant in place paying rent under the tenancy agreement. That the arrangement, in my submission, would be a way through the vehicle through which the authority obtain the necessary information to satisfy the requirements of Article 3.
Can I just pause there, because we looked earlier at the guidance,
My lady, yes.
paragraph 17 on page
Yes?
218, which talks about, which you were relying on,
Yes.
ensuring that the property is visited by the local authority. As I understand what you've said just now, I think you say it would be possible for that to be dealt with not by visits on behalf of the local authority directly, but by appropriate checks
My lady, if
by St Mungo's and confirmation of that. Have I understood you correctly?
my lady, yes, because if you look, if my lady looks at para 1717, the advice that's being given is that it be visited by the local authority or someone acting on their behalf.
Well,
So-
yes, I was. It's a question of what, if that
Who's- does
guidance
that
is
mean?
relevant, what
So-
on their behalf.
Where there's, and we can see from the explanatory memorandum that there's reference to the accredited landlord scheme, and local authorities do have accredited landlord scheme. So the landlord goes through a process to determine whether they're a fit and proper person. And if you have a registered provider like St Mungo's, who no doubt is who is no doubt a fit and proper person, and has able to demonstrate again the certificate that will be granted saying you're a fit and proper person, member of the accredited scheme, then it would it be irrational for an authority to rely upon the likes of St Mungo's to delegate them on their behalf to go and check and provide a property report. One would find that difficult to be able to run an argument that that is perverse in the Westminster sense. But if you're presented with a private landlord who, as I think my learned friend Mr Peacock refers to as a rogue landlord, who has had a difficult and checkered past, coming forward with accommodation, one would say, well, actually, in that instance, it wouldn't be reasonable to rely upon him to provide the property checks to ensure it's in reasonable physical condition. The local authority would, in such circumstances, if they've considered him to be currently fit and proper, say, well, we actually want to check it ourselves because you've got a checkered history. So there will be circumstances when the local authority would have to check the property. But what the bottom line is here in my submission is that there has to be a check of the physical condition of the property. No assumptions can be made in relation to either the physical condition of the property or indeed an assumption that the, for example, the relevant certificates and licenses are in place. That is as I describe it, a process of assessment based upon documentations being produced by the landlord. Because the landlord has the EPC, the electrical certificates, the carbon monoxide, what steps he's taken to prevent or to reduce the risk of carbon monoxide poisoning, and so on and so forth, fire safety, gas inspection reports and so on. That's all within the control of the landlord. So going back to section 7a little b, subsection 7a little b, in pursuance with the arrangement with the landlord, what I submit is what Parliament's intended is that just because a landlord rocks up and says, well, I've got a property with an assured, I can offer an assured short-hold tenancy, the authority are required to go through Article 3 and, in part of that arrangement, require the landlord to provide the necessary information so that the requirements are met. If it were the case that a local authority can say, well, in the absence of any information, see no evil, hear no evil, speak no evil, I can make the assumption that that Article 3 is not engaged. It leaves it open for property to be let to vulnerable applicants which are not meeting one or more of those requirements, i.e. there could be property that has a problem with carbon monoxide or a property that is in disrepair. And it doesn't follow in my submission that just because a landlord is a fit and proper person, that all properties that are under the control of a fit and proper person are in a state of repair and good condition. We know that's not the case given the number of disrepair claims that are dealt with by the lower courts on a regular basis.
Can I just understand your point about accredited landlords? I think you said it's a scheme under which the landlord is assessed as a fit and proper person.
Yes.
Are you suggesting it? I mean, I assume both of the landlords in these cases fall into that category, or
Well,
do we not know that?
We can only assume.
Right.
can assume.
Let's assume they do for the
Yes.
moment. What I suppose I wanted to understand is whether you're saying that assessment or the concept of accredited landlord would not extend to cover the sorts of matters we're talking about, for example, to do with the physical condition of individual properties.
The question of fit and proper person, if I can take Milady back to the order itself, it's specifically at page 208, bottom of page 208, 208A in the authorities bundle. There are a number of, it's looking at the capacity of the landlord and looking at whether or not he's got convictions and has exercised, and so it's quite a wide, broad brush. So, but it's not.
But you're not really targeting that subparagraph.
No.
Nobody suggests that St Mungo is
No.
not a fit.
No, I'm not suggesting that at all. But I'm just trying to a sense of understanding how the scheme operates. Yeah. Just because a person is a fit and proper person, that deals with the capacity of the landlord. It doesn't deal with the property. Yeah. There are two distinct areas that need to be addressed: the property and the landlord, and then the tenancy agreement. So there's three specifics, and that's what the local authority are required to assess. Now, my Lord,
when you refer to accredited landlords, are you referring to statutory schemes, non-statutory schemes? I mean, in what sense do local authorities accredit private landlords?
My Lord, the local authorities have an accredited scheme for licensing purposes. So,
but you don't generally need to be licensed to be a private sector landlord. There are many private sector landlords who have no licences at all. What do you need a licence for?
If you're an HMO and you require a licence, then they will have to assess the landlord where there's an additional licensing or selective licensing areas under the Housing Act, Part 3 of the Housing Act. Then you cannot operate without the license. So there's layers of control, and that is intended to look not just at the individual landlord, but also at the property and controlling the extent to which the property is used in terms of numbers. Local authorities have got to adopt voluntary accredited schemes, which whereby the authorities look at individuals and decide whether or not they are fit and proper.
But for what purpose?
For the purposes of licensing, principally.
For HMOs? For
HMOs, or beyond.
What's Part 3 that you referred to?
Part 3 of the Housing Act 2004 deals with selective licensing schemes, and the local authority can adopt a selective licensing scheme throughout the whole borough, which requires licences to be obtained for the renting out of properties. But there are levels of where you've got to satisfy certain criteria of approval and so on and so forth to be able to do that. But so there are within the licensing frameworks schemes whereby accreditation can be obtained. But just because you're accredited doesn't follow that you'll be a fit and proper person, but invariably probably will be. But the authorities still need to address subparagraph E to make sure that the applicant, the landlord is a fit and proper person. I mean, my Lord, I take my Lord back to the explanatory memorandum, where there's reference in the in paragraph 7.5 at the bottom of page 212, bottom of paragraph 7. The last sentence of paragraph 7.5, at the existing landlord accreditation schemes across the country. So there are schemes that are available.
Well, sorry, just interrupt again. But the way I read 7.5 and 7.6 is suggesting to me that accreditation schemes can cover property-specific matters.
Well, the existing landlord accreditation scheme is dealing with, as I understand the accreditation schemes, it is looking at the landlord, not the property.
Well, what's the first sentence, 2 sentences of 7.6 saying? Looking at common elements of those schemes.
Yes. My lady, yes. I mean, the 7.6, how they operate in practice. The difficulty, in a sense, is that for the purposes of approving under section 193(7)(ac), the suitability of the accommodation, one's not guided by the accreditation scheme, one's guided by Article 3(1).
Indeed, I'm simply at this point trying to understand the points you're making.
Indeed.
Whether accreditation covers any.
The accreditation scheme may overlap with the requirements of subparagraph E. It may be that it's a given that, for example, if St Mungo's is approved under the accreditation scheme, that they therefore satisfy subparagraph E. But the question has to be asked by the authority in respect of the landlord with whom the property is going to be offered to the applicant, whether or not they are a fit and proper person. It may be a simple, straightforward exercise because they have been accredited under the scheme that the authority operated at that time.
Well, you say that even if, as is plainly the case, St Mungo's is a fit and proper person, one can't assume from that every property they offer is in reasonable physical condition.
Indeed. And that the certificates and the licenses are up to date, or that they're not expired. You know, those are issues that need to be checked. And the question is, does this list of regulatory requirements impose an onerous duty on the local authority, such that it can't be the government's and Secretary of State's intention to require extra work to be done by the local authority before they can rely on the private sector and the use of assured total tendencies to bring the duty to an end? And my submission, the answer is no, there isn't any additional onerous responsibilities being placed on the authority because of the arrangement that they will no doubt reach with the landlord to provide them with the necessary information. And it's a straightforward exercise of the authority, the officer in charge, going through and making sure all the boxes are ticked.
Would it be enough if in the arrangements made under section 193(7)(b), local authority said to the proposed landlord, St Mungo's or some other housing association, before making an offer which is intended to be a private sector rental offer for the purposes of section 193, you need to satisfy yourself the property is in good physical condition, the electrical installations are working, all necessary certificates have been obtained, and you need to certify that to us. Is that enough? Can the local authority just say, it's St Mungo's, they've told us it's okay, or do they need to know more than that?
My lord, they need to know more. They need that in terms of the physical condition, I accept the physical condition of the property, the inspection report, the code of guidance says it's either the officer or someone delegated.
So they actually need, it's not enough for St Mungo's, an entirely reputable housing association, to have agreed in the arrangements that they won't let unless they're satisfied it's in good condition.
No.
They need to send the local authority a piece of paper saying, flat 37, we looked at it last week and it's fine.
But they need to send the necessary, the licenses, certificates, the
An individual report of an individual property for the purposes of each offer.
Yes. So that the officer who is, because the officer is in the position of knowing the vulnerable applicant. That's the whole point of the protection, is to avoid vulnerable applicants being put in private sector accommodation, which is of poor quality. And what is poor quality? Accommodation that doesn't meet the requirements of Article 3. That's we can see that from the explanatory memorandum. So if any one of those requirements are not satisfied, it is poor quality accommodation. The advocate for the applicant at this point is the local authority, to ensure that the accommodation that's being provided is suitable. And this is what the Secretary of State requires them to do, to ensure that it is suitable and that it meets the necessary standards. And that it means, in my submission, providing the necessary licenses, certificates, and documentation that is identified within Article 3, and providing a copy of the agreement if it's not already been provided.
Well, under physical condition,
Yes.
it's not simply a matter of, I think we all understand what an electrical safety certificate is, but there isn't a physical condition certificate. Are you saying there has to be a report of an inspection
Yes.
by somebody?
Somebody who was able to look at the question of dampness and heating, to ensure, because we see that in the Code of Guidance at 1717, page 218. So that's why there needs to be the physical inspection, to make sure just prior to the offer being made that the accommodation is in a reasonable physical condition, i.e. doesn't suffer with dampness, it does, the heating works, and so on. So once that inspection has been carried out, once the necessary documentation has been provided, the authority can then check that information and read the report and then decide whether or not it is suitable. And it's only at that point that they can then approve, once they then check where the tenant, where the applicant's living, make sure they're not under any contractual obligations they can't get out of, and then at that point they can approve the PRSO. At that point, the applicant knows nothing about this.
Well, I understand that point. But your submission is, it's not enough for the local authority, let's take little a, physical state,
Yes.
to say, I haven't heard anything bad, and this is a perfectly reputable landlord, and we agreed in our arrangements with the landlord that they would only let properties in good condition. That's not enough. They actually have to have a piece of paper saying, here's an inspection report,
Yes.
and the property is not damp, not cold,
Yes.
and all the electrical equipment is working.
Indeed. And that's what is required in my submission, yes.
And until you do that, the local authority can't properly reach the conclusion that it's suitable.
It's suitable, and therefore cannot approve the offer because it's not suitable. And if they can't approve the offer, any offer can't be a PRSO because it requires approval.
I understand all that.
Now,
You have the approval stage
Yes.
before the offer is made. I understand that. The question is what the local authority has to have in its hands before it says, I'm going to approve this offer.
Now, my learned friend Mr Peacock says there may be circumstances where assumptions cannot be made, and therefore they have to make the checks. So it's accepted that the local authority may, in certain circumstances, be required to carry out the assessments that I say should be carried out in every case. because, and I believe it's because of, for example, the example that my learned friend gives us of a rogue landlord. If that's the case, how is it, in what way can Article 3 introduce that level of control to ensure that local authorities have to make inspections of, for example, of the property, or inspections of assessments of fit and proper person, that enables, in a sense, that caveat or qualification to be added to the operation of the article, so that in certain circumstances, using St Mungo's as the example, the authority can make assumptions, but in the case of Mr A, they can't make the assumption. There's nowhere in the scheme where it can be read into that Article 3 that a caveat can be read in that requires authorities in certain circumstances to carry out the necessary checks under Article 3(1)(a) to J. If the government, or if the Secretary of State intended to give the authority the scope to presume satisfaction, I believe my learned friend Mr Grundy puts it, the presumption of satisfaction, that would be clearly set out in the article, so that the authorities can say, well, we've decided, for example, if the landlord is a fit and proper person, you can assume that all paragraphs, subparagraphs A to J, are satisfied. Now,
but you say you can't assume, even if there is an actual were to be an actual agreement in place between the landlord and the local authority that specifically says, for example, before offering any property, we, the landlord, will have done the following checks. You say that's not enough.
That's not.
There needs to be a positive confirmation.
I'd say on the way that the act, or the way that the order is written, I say that is the only conclusion that can be drawn. But for the purposes of exploring this, the argument that my learned friends postulate, namely that there's a presumption of satisfaction, but that in certain circumstances, the due diligence, I think was the word that the judge used, that there would be a due diligence required. But there's no way in which that due diligence requirement can be read into the wording of the article as it's framed within Article 3. And indeed, it would for this court to introduce that caveat at this stage, giving a presumption of satisfaction of the articles in the event of, for example, the landlord being a fit and proper person. That drives a coach and horses through the scheme, the article and the intention of the scheme, enabling local authorities to close their eyes, put their hands over their ears, and avoid having to make inquiries and then assuming, in the absence of any information to the contrary, this is suitable accommodation. It would be in the landlord's interest not to provide the information that Article 3 requires. And it would be in the authority's interest that not to ask for that information and then be able to come to a court in defending a decision saying, well, we're entitled to operate in silence and make a decision that the property is suitable because there's no evidence to the contrary.
Mr. Kelville, the offer letter from the local authority at page 85 says...
This is, my lord, the Westminster.
Yes.
Yes, to Mr Hajjaj. It says at the bottom of 85, we believe this accommodation is suitable for you and we hope you like it. In our view, it is large enough, affordable, etc.
Indeed.
And then in reasonable condition. I don't know whether Mr. Peacock is going to say we have to assume that that is based on evidence, but do we know?
We don't. One of the points that I was going to make in respect of the specifics of each appeal was in respect of the Westminster decision. There is no material against which one can point to and say that satisfies A, that satisfies B, that satisfies C. These are assumptions that are being made, and as I understand my learned friend's argument, he's entitled to assume, based on his construction of Article 3, that in the absence of evidence to the contrary, it is open to an authority to assume Article 3 is complied with. That, in effect, reverses the burden onto the applicant to prove that the accommodation doesn't, for example, have the necessary licenses or certificates. But that's not how the article is framed. It's not framed that the applicant has to prove, but it's for the authority cannot prove an offer if it's not suitable, and it cannot be suitable if. So the burden is on the authority, and it cannot be right for an authority, to my submission, to contend that the burden is transferred to the applicant on approval to prove that actually one of the requirements or one or more of the requirements have not been satisfied.
Well, as my lords pointed out, in this letter they say, in our view, which picks up the wording of Article 3, it is in reasonable condition, reasonably safe, meets all the legal requirements, electrical equipment, gas and carbon monoxide safety, and energy performance. Now, I think what you're really saying is they had no material on which to reach that view.
But my lord, to take it to the next step is that on a review, when a review is requested,
yes, the
review must be a reconsideration as to the suitability of the offer, the PRSO. So it's a fresh decision. The authorities of Timor and considered in the case of Salah, both decisions are in the bundle. And Lord Justice Lewison deals with the question of what is a review, and it's a reconsideration of the question of what duty, if any, is owed, or whether the accommodation is suitable for the purposes of the private rented sector offer scheme. So it is a fresh determination of the issue. What?
Well, one thing at a time. You'll no doubt take us to the review decision in a moment, but you said in your submissions earlier that before making the offer in the first place, and yes, here is the offer, the local authority must be satisfied of the various requirements. Otherwise, they can't approve the offer by St Mungo's,
yes,
and they can't make this offer themselves, you say.
Yes. So therefore, if they cannot approve the offer, then the offer that is made by the private landlord is not a PRSO, and therefore cannot bring the duty to an end.
How do the two offers interact? This is the local authority offer.
Yes.
30th of April 2019, and then in the supplementary bundle, there's a document from Real Lettings,
yes,
part of St Mungo's.
Yes. My lord, the document your lordship's referred to in the supplementary bundle is in the supplementary bundle, page 38.
Yes.
Yes, and that's the that is a report by Real Lettings, so as it describes itself, a social letting agency and part of St Mungo's, and it then on page 39, it is describes the property.
Yes. What was done with this document? Who was it sent to?
Well, my lord, what we have here is what the documents that were before the reviewing officer.
Right.
So he did not have, all he had, he had the report as to the actual what the property was and its layout, at page 38, 39. The page 40, 41 are the availability notice and nomination form, which doesn't provide much further detail. And that is the extent of the information that was before the reviewing officer.
But this document, including the nice colour photo,
Yes.
page 38, is that sent to the tenant or prospective tenant, or simply to the local authority?
My Lord, I can't answer that, other than all I know that this was on the housing file.
Yes.
And that information was before the reviewing officer. So when the reviewing officer undertakes the review, the officer has to carry out a make a fresh decision on the issue, whether or not the accommodation is the offer is a PRSO for the purposes of section 1937AC, and he's got to look at the question of Article 3 and the requirements. And as I understand, and it's right that the offer letter, as my Lord Justice Nugee states, does refer to the information, namely that they are to view that the accommodation is reasonable condition, reasonably safe, etc. But that's just a statement of fact. Now, in the offer letter, I accept they are not required to give reasons for their decision or their offer. The offer can be made, and it's a simple offer. But when it comes to a review, the reviewer has to look at and make if it's going to be an adverse decision, namely that the accommodation is a PRSO, then that is an adverse decision because it brings the duty to an end and there's no further accommodation to be provided. They have to give a reasoned decision, and it requires an assessment of the requirements of Article 3. Now, my learned friend's argument is, well, they were entitled, if I can take your, just to complete the circle in terms of the facts of the Westminster case, the review decision can be found in the core bundle. It's dated the 23rd of September. It's at page 64 of the bundle. And it runs to page 83. And the officer states that it sets out what she is dealing with, and then at page 68, second paragraph, the court will see it was raised in the representations on review, as repeated in the review decision letter, that there doesn't appear to be any evidence that the criteria, that's A to J, of Article 3 have been determined as not applicable. You state that it is a requirement. You state that it's a requirement that is shown that the criteria do not apply, and that the offer of private rented accommodation is suitable. You state that these steps not having taken place, the offer could not be deemed as suitable for the purpose of Article 3. So what's being raised was there's no evidence to satisfy the requirements of Article 3.
Yes.
And the response to that can be found at page 80 and 81 of the decision letter, where the officer states, under the heading of Article 3 at the top of page 81, I note your reference to Article 3. I am satisfied that sufficient regard was had to Article 3 when the offer of accommodation was made to Mr Hajjaj. There is no assessment of Article 3, indeed there couldn't be. It was an assumption that the requirements were made, and indeed that's how it was argued and is now argued in this court, that it was open to the officer to assume compliance with Article 3 in the absence of evidence to the contrary, given that this was an offer made by by St Mungo's, but there is no consideration, and indeed there is no evidence. So in this instance, in this appeal, not only was there no evidence, but on review, when there has to be a fresh consideration of the issue of whether or not it is a PRSO for the purpose of section 1937AC, the officer chooses basically to endorse the original decision, which is not in dispute. It's been dealt with by numerous courts. A review is a fresh consideration. It's not a rubber stamping of the original decision. You've got to address the issues. And if it's going to be concluded that, well, having an Article 3 having been raised, as there is no evidence, it's been put to the fore that there is a requirement to meet, there are requirements to be met, there is no evidence to prove, therefore it cannot be suitable and it cannot be a PRSO for that reason. And it's not, in my submission, a lawful response simply to say that the offer there was satisfied sufficient regard was made by the original decision maker in the offer.
Are you making 2 points there? One is the reviewing officer has to decide for herself rather than simply looking at what the original decision was. And the second was she needs positive evidence that Article 3 is satisfied.
Yes.
And you say, having regard to what was in the bundle, there wasn't anything at all.
There wasn't anything at all. And therefore it wasn't open to the officer to come to the conclusion that sufficient regard was had. On what basis can it be said there was sufficient regard when there's no evidence to... It is said, well, this is St Mungo's, and therefore we can assume. Well, in my submission, the Article 3 doesn't give scope for any such.
You've made that point. And it isn't a case law to which some of you have referred us that the local authority don't have to give reasons in the original offer, but they do have to give reasons on the review.
My lord, yes.
And you say that the top of page 81 doesn't give any reason.
Doesn't give any reasons. And the reasons have to be addressing the issue of suitability in order to be a PRSO, not reasons why there was sufficient regard made by had by the original decision or in the original offer. So the reasons have to be specifically addressing Article 3, but they don't.
All right, is there anything else we need to know about the facts in the Hajjaj case?
In the can I take, my lord, and take the court to the Waltham Forest decision?
Yes.
Because the authority in that decision, the review decision can be found at page 116 to 143. And that was a review in respect of decision that 59 Dadswood Road, Haydens Road, Harlow, which was out of district placement, that accommodation was not suitable and was refused. The offer, the original offer, can be found at page, in the supplementary bundle, at page 35. In this decision, in these facts, the court will see that there was further information, more information than what there was, we can find with the absence of information that we see in Westminster. Starting with the offer on the 25th of February 2020, the offer, at the bottom of the page, Ms Akhter is informed that Mears Housing Management, managing on behalf of More Homes WF, will contact you within 2 days to arrange an appointment to view. Please note that it's a private rented sector offer. Turning over the page at page 37, bottom of page 36, the Council considers suitable for you and your household. In reaching this decision, this is a suitable offer, accommodation, discharge the duty the Council has been fully considered. And then we go to the point 2 on page 37. I have also considered accommodation offered is in view of is in the view of the Council reasonable condition, and used the guidance in part 2 of the 2012 order to help guide me on the suitability of accommodation offered itself. Mears Housing Management will provide you with copies of the landlord compliance information, EPC certificate, gas safety certificate, electrical safety certificate. We have a number of documents that are on the housing file, so therefore must have been before the officer, both in terms of the offer and in terms of the review. And the first document is, we can see at page 55, is the sign-off documentation. And there we can see down on page 55, ticks being entered in respect of the property. And the type of property is a 2-bedroom flat with electric heating and night storage. On page 58, 58 to 63, you have the electric installation certificate. At 64 to 90, we have an asbestos report, not required under the article, but it's an asbestos report. It runs lengthy report to page 90. At page 91, we have a fire risk assessment report, starting at page 91, running through to page 104. At 105, we have the EPC, the Energy Performance Certificate. So a number of documents being provided.
Now, who gets to see these?
Sorry, my lord.
Who gets to see these?
They are on the housing file.
Right.
So therefore, they must have been available, but we know they're in front of the reviewing officer. Whether one would assume they were in front of the officer making the offer, but they were certainly on the housing file. As a result of the offer, an inspection, a viewing was arranged, and Ms Akhter, page 33, sent an email, and there's 2 emails concerning the physical condition of the property, and the points that I would draw the court's attention to would be at the bottom of the page. The number of complaints, one in relation to the particular the water taps not working and the toilet having been used but not flushed, because obviously the water has been turned off. It was not in a clean state. But at the bottom of page 33 in the 20th of the 20th of February email, upon viewing the property, I was raised several concerns about the state. Note there is damp in parts, which looks to be unprofessionally painted over, and then concern about the water not working properly. Heating doesn't appear to be working properly either. So those are the two physical aspects of the conditions of the property that I would indeed relied on and do rely on in this hearing. So the authority were put on notice that there was a concern regarding the physical state of the property. Page 52, inquiries were made, and the response at page 52 was that there were no works required of the property, and then the issue with the water was that the had been turned off, and as a result the water pressure wasn't there and the toilet hadn't flushed. But the concern was, and the complaint was, that there was dampness in the house and in the property, and that the heating wasn't adequate. And this is a lady who has a child who has health problems, and indeed we see that now medical, who advises the local authority, were asked to advise, and we have their response at page, in the supplementary bundle at page 2. The response was that if the accommodation, that the offered accommodation as it stands would be unsuitable unless the aforementioned difficulties were addressed. Therefore, the damp were treated adequately, adequate heating to be installed, and any disrepair issues could be addressed. Then there would be no medical objection to the current accommodation. I.e., if it doesn't, if there's a damp issue in the heating, then it wouldn't be suitable given the medical conditions. The authority then reached their review, the decision on the review. If I can take your lordships to that. The state, my lord, that's at page 116 in the bundle. And I'll address your lordships on the out of district placement in due course. But in relation to the disrepair, we can see at page 136 onwards, under the heading of disrepair, the approach that was taken in relation to the disrepair and Article 3. And the authority there say that...
sorry, Mr. Calvert, which page?
Page 136.
Are we in the main bundle?
In the main bundle.
Ah, okay. Sorry, does this date of the review letter follow the now medical?
Yes.
So we've got that now medical report on the 12th of August.
Yes, and
the review decision starts at
page 116.
12th of October.
Yeah, so the now medical comes in before the review decision. And at page 136, if I can take the lordships lady to that part of the decision letter, paragraphs 108 through to 115 deal with the question of the disrepair and Article 3. And at paragraph 111, the officer states the agent would have repaired this problem referring to the water, as they would have done with the heaters emitting enough heat and cleaning and repairing the toilet. Based on what I consider minor disrepair issues, you refused the offer of accommodation, and even though you informed the viewing officer about the repairs required, you felt the viewing officer made excuses. I don't find advising you that repairs would be carried out as excuses After all, these are issues which could be repaired. At 113, the property has been inspected and I've attached the certificates for the property and have reviewed that the watermarks in the kitchen are likely to be signs of condensation. As I noted, you did not report signs of mildew, dark patches of discoloration, or that the walls were wet when touched. Therefore, it's unlikely there was damp in the property to cause your daughter's asthma to worsen. I do not find that the property was unsuitable, as the agents would have been instructed by the council to complete the disrepair issues you reported. It is unfortunate the toilet hadn't cleaned before review. However, presentation of the property did not make the property unsuitable. In making my decision, I consider Article 3, where the council, making a PRSO, must make checks that the property is suitable. I find the property was suitable in terms of physical condition, electrical equipment, meeting the statutory requirements, reasonable fire safety precautions, and precautions preventing possibility of carbon monoxide. What's missing in the list is the consideration of the tenancy, the written tenancy agreement that is being offered.
This is under a specific heading of disrepair.
Well, this is the only point at which, the only point where the authority addressed Article 3.
I see.
It's under that heading of disrepair. But the Article 3, as the court will have seen, it deals with a lot of different issues, not just disrepair. And there is no reference to, nor has the agreement been considered or considered to be adequate, and therefore there is, in my submission, clear failure to comply with the requirement, little J, subparagraph J, which, on the wording of Article 3, means the property cannot be suitable. There is reference to, in the decision letter, to the precaution preventing possibility of carbon monoxide, and it's right that there's the heating is electric heating, but it is a flat, and there's no consideration of the question of carbon monoxide poisoning, indeed coming from a neighbouring flat or from another source, and it's not been addressed in my submission, other than by reference to I have considered precaution preventing possibility of carbon monoxide poisoning. It's not addressed in terms of the information that's been is before the authority. And then finally, in respect of the disrepair, the approach taken is, well, if there are disrepair issues, they can be dealt with and repaired once you've taken up occupation of the property. In my submission, that's reversing the effect of Article 3.1a. It's not a case that a local authority can discharge their duty by offering a private rented sector accommodation that is in disrepair and say, well, it's suitable because we can repair it once you're in there. It has to be in a reasonable physical condition before it can be approved, not retrospectively.
Is that a complaint about the decision on the facts, or a complaint about the law? As Akhter said, the property wasn't in reasonable physical condition. There was an inspection on the 31st of January, less than a month before the offer. She goes there and finds, and it seems extraordinary that anybody bothered to turn the water on or find that the toilet was in fact working, capable of working. But how was the judge supposed to resolve that issue?
Well, the approach taken by the judge was that if there was disrepair, it could be repaired after you've taken up occupation. You've got repairing obligations within the tenancy agreement. You can enforce those if they're not there; they can be implied. Whereas, as a matter of law, the approach that's been taken by the authority and endorsed by the judge is putting the cart before the horse. You're saying that, well, yes, even if there is a disrepair issue, you can resolve that once you're in there under your rights and obligations in the tenancy agreement, as opposed to, well, you should not be letting out accommodation that is poor quality accommodation. And that's the intention of the article, is to prevent poor quality accommodation being let to vulnerable applicants. And it cannot be right, in my submission, for local authorities to say, well, this accommodation, albeit it's not, if there is disrepair, it can be resolved once you've taken up occupation, therefore satisfying, therefore it can be deemed to be suitable. That's reversing the effect of Article 3 and saying, well, we don't have to be satisfied that it is in a reasonable physical condition at the date of the offer. You can accept it and then enforce your rights. That, to my submission, is not a lawful approach.
So just to clarify, the point about dealing with them after occupation, is that something in the judgment below, or is it in the review decision?
My lady, I said it's both. But principally because we're looking at the review decision. It's in the review decision. It is like paragraph 109. I hope the disrepair problems were resolvable and didn't prevent you from accepting the offer. So and then we have at 113 this finding, but there's no evidence to support that. Well, it's an assumption that the dampness is a sign of condensation. This is a property that's not actually lived in, and it's cold. So one has to ask the question: where's the condensation coming from? If it's a fresh let, in a sense, and indeed, when we go back to Miss Akhter's representation, following visiting the property, she talked of the property having been. It looked like there's damp. The property looks like it's been unprofessionally painted over. So attempts were taken to cover over and paint over the dampness. So my submission, what the authority have got wrong, and again the approach adopted by the judge, was that this was something that can be resolved, and therefore shouldn't be. It's still suitable because you can resolve it under the terms of your tenancy. That, my submission, is reversing, right, and is not a lawful decision to say that it is suitable because of the tenancy obligations. Indeed, we don't even know what the tenancy obligations are because they haven't produced the tenancy. The mayors haven't produced the tenancy agreement, and the tenancy agreement hasn't been assessed by Waltham Forest. It follows, therefore, that Waltham Forest have fallen into the same mistake as Westminster in making assumptions, and in particular assuming in silence that the agreement is adequate, considered adequate. My learned friend, on behalf of the authority, argues that, well, Article 3 wasn't raised in the review representations and therefore they were not bound to consider the Article 3 save for the disrepair issue because that was raised. My submission, that's one, Article 3 arises for consideration before the offer. The court has my submission on that. I'm not going to repeat
Yes.
it. It doesn't. The burden is not on the applicant to raise that as an issue. And indeed, the decision of this court in Peretti, which qualified Crown, where referred to the need to make representations and the authority can't be criticised for not taking into account something that wasn't put before the authority in the representation or review. In Peretti, it was the decision, the applicants were disabled, but they didn't raise their disability within the context of the review, and the court held, well, the court were aware of the disability, and therefore the public sector was engaged, and the authority couldn't avoid considering it just because in that question of disability hadn't been raised by the applicant. The same must apply here. It's not necessary for the applicant to raise Article 3, albeit in Westminster decision it was raised, but it's not required for the matter to be addressed. The authority have to address it, and they have to address it not only before the offer is made, but when the review is undertaken. That review requires an assessment of the of Article 3, and it's that is in my submission. Peretti supports my submission that the Article 3 had to be considered in its totality, including in this instance the question of the tenancy agreement. The absence of such means that the accommodation is unsuitable. My Lords and my Lady, His Honour Judge Gerald, in giving judgment, referred to the arguments I've advanced to this court in terms of Article 3 as being technical and seeking, giving a charter for applicants to, I use my own words, and to try and avoid the consequences of rejecting a PRSO in the hope of getting something better. But my Lord, that's not the intention, nor indeed in my submission that's not the raison d'etre for the article. It's not a technical argument to avoid the consequences of the discharge, automatic discharge on rejecting. It is a requirement that has been a regulatory safeguard and safety net that's been put in place by the Secretary of State and Government to ensure that vulnerable tenants are not put in a poor quality accommodation, and every requirement, A to J, must be satisfied. And in the absence of such, in my submission, the authority cannot approve the offer, and the duty does not come to an end on rejection of those offers. In those circumstances, on this common ground, both appeals should be allowed because the court have endorsed in both cases that the local authorities can make assumptions that there is compliance in the absence of evidence, and therefore the authority can avoid having to consider the full effects of Article 3 to protect the applicants generally. Let's take us further on that common ground. There is the additional ground, but I'd be guided by my Lords in terms of ground 1, the Akhter appeal. Whether you wish to hear from my learned friend Mr Peacock dealing with that, and then I can deal with.
Why don't you cover the additional ground now?
Can I then move on to the additional ground,
yes.
Which is this? It deals. I can deal with it quite shortly. The additional ground deals with the offer of accommodation made by Waltham Forest, and which is an out-of-district placement. And Section 208 of the Act provides that local authorities should secure. My Lord, take your Lordships just to it for reference. It can be found in the authorities bundle at page 203. And it's 203.1. Sorry, it's 208, page 203. Section 208.1. So far as reasonably practicable, local authorities shall discharge their housing functions under this part, secure that accommodation is available for occupation in their district. So the guidance was given in by the Supreme Court in the Zolomesu, which Lordships have in the bundle at it's tab 6, page 105, it starts at page 105, and this was a out-of-district placement by Westminster into Milton Keynes, and the challenge was made in respect of failure to discharge the duty under section 208. Needn't take trouble your lordships on the facts, but at page 119, Baroness Hale gives guidance to the how to deal with out-of-district placements, given that such placements where the authority accept the duty that they owe to the applicant by placing them into the district of another authority, places an additional burden on that authority who never accepted the person in the first place, and it needs to be carefully managed. And in paragraph 38 and 39, in summary, what Baroness Hill was advising was that local authorities should have both a procurement policy and a placement policy to ensure that the accommodation that they were going to be using for allocation in discharge of duty, both temporary and in this case under the PRSO, that the policy will ensure that those who should be accommodated within the district and have greater need, given the shortage of their accommodation that there is within London, which is accepted, that they get identified for that accommodation as opposed to someone else, and so on and so forth, and there's grades and banding. But in terms of procuring, the authority should have they will know what accommodation they need to procure in their area, and need to ensure that they keep up to date their policy for procuring sufficient units, because they will know from past experience how many units they need in any given point in time to meet the anticipated demand during the coming years, and how that the need will be met. So there is clearly, and if I can, before I make my submission, take your my lords and my lady to the Code of Guidance, and it's at paragraph 1757, and that can be found in the bundle at my reference as well.
17.48.
17.
Page
219.
219.
I'm grateful. Thank you very much. 1748, page 219. Housing authorities, particularly those that find it necessary to make out-of-district placements, are advised to develop policies for the procurement and allocation of accommodation which will help to ensure suitability requirements are met. This would provide helpful guidance for staff responsible for identifying and making offers of accommodation, and would make local arrangements and the challenges involved with sourcing accommodation clearer to applicants. So what the authority is required is advised to do is to adopt both a procurement and an allocation policy to ensure that, particularly where accommodation, they can't meet accommodation needs within their own district, how they will then determine who gets that limited supply and who will be placed out of district and how far from the district. In my submission, as a matter of principle, there should be both a procurement policy and a placement policy adopted by the authority, so that it is clear, following the guidance given by Baroness Hill, it's clear what to both applicant and to the court as to how the duty under section 208 is discharged. And where there is only a placement policy, in the absence of how they need that they can identify from their experience how that need will be met through procurement. The placement is in again is in a vacuum and is shrouded in mystery, because we don't know how they are, because the local authority, it's not clear how the authority are procuring the accommodation that they need, and therefore if they're not procuring accommodation within their own district, then it follows that they have to place out of district. So the principle is that there should be, the starting point should be to procure accommodation within district, and the procurement policy will set out what their need is and how they propose to procure that accommodation within the district. And then an applicant will know what steps are being taken and the chances are of being accommodated within the district. In this case, Ms Akhter was accommodated in Harlow, which is out of district, distance away, and the location was an issue that was raised within the review. What we have in terms of policies, my lords and my lady will find the policies in the supplementary bundle at page 109. We have the temporary accommodation allocation policy, which is supported by a temporary accommodation acquisitions policy. So they both work together, acquisitions seeking to procure the accommodation that's necessary for temporary accommodation allocation. And the structure in page 109 to page 114 is, in effect, in summary, a banding system, and those with greater need being accommodated in the lesser, the accommodation, small accommodation, number of accommodation that can be sourced within the district, and therefore allocated according to those in greater need.
I quite see why applicants should be able to know what the local authority's allocation policy is, but has it ever been held that councils must explain their procurement policy?
It's not been held. I rely on the approach that Baroness Hill refers to in the Zolomess, that there should be both allocation and procurement policies. The Secretary of State advises that there should be both allocation and procurement policies. One can't just simply allocate. One has to, the procurement policy, in the context of the duty under section 208, so far as is reasonably practicable, to accommodate within the district. In my submission, every authority should have a procurement policy to meet the need that they identify as being, that needs to be met during the period of time every year. That's what Baroness Hill referred to as each year. They know what accommodation they will need to procure to meet the need, so that they're not then placing applicants in other authorities and placing a burden on those other authorities and avoiding having to carry the burden themselves. So there has to be a procurement policy. The question is, my lord has raised, is does the applicant need to know what the procurement policy is? And my submission is yes, they do. Because if an authority hasn't got a procurement policy, or indeed they have a procurement policy and say, well, we'll only procure 10 houses, 10 units, even though we know we need 100 units, we know that their policy is not going to achieve that which they need to achieve, namely the 100.
Sorry, are you actually going so far as to say that not only must the policy exist, but it must aim to provide all accommodation inside the district?
No, I'm not saying it should, so far as is reasonably practicable, using the words of section 208. It should seek to comply, well, it's got to comply, it's a matter of duty. It's got to comply with section 208, but so far as is reasonably practicable, gives the scope for authorities to say, well, I can't procure within my district because I don't have sufficient accommodation to be able to do so. But we are going to identify accommodation elsewhere in neighbouring boroughs and so on. what my argument is, my lords, my lady, is that the authority for Waltham Forest do not have a procurement policy for the PRSO. They have a placement policy, and for the purposes of transparency in discharge of duty, namely the duty being, so far as reasonably practical, to place within the district, there's no measure, there's no way in which an applicant, or indeed the court, is able to assess whether the authority are actually discharging their duty under Section 208. And that, I do say, that an applicant and indeed the court should be asking authorities and expecting authorities to produce such documents. They produce a policy, a procurement policy for temporary accommodation, but not one for the operation of the PRSO, which is separate and standalone allocation.
Right, so the policy you referred us to on page 109 is not which refers to temporary accommodation.
It's all to do with temporary accommodation. It's not PRSO.
The relevant policy.
No, but my lady, the reason I referred my lady to that, the court to that, is because at 1.2, this document should be read in conjunction with the temporary accommodation acquisition policy, which is effectively the procurement policy. But when we look at the PRSO policy at page 115 through to 120, that's a policy dealing with high accommodation is offered and allocated, and you can see it 3.2, zoning, and so on. So, but what we don't have is a procurement policy, which is what both Baroness Hill and the Zolomesu and the Secretary of State Code of Guidance advises. I see my lord's troubled.
Well, this seems to me a huge issue, and that you're saying that a local authority cannot validly, well, let's put it this way, they can't validly enforce the one strike and you're out rule unless they can satisfy the court that they procure an adequate number of in-district properties to meet needs.
My lord, I don't go that far. What I go as far as to say that there should be a policy in place where they discharge their duty under Section 208 to procure, so far as is reasonably practicable, accommodation that is necessary to discharge the duties that they have accepted. So it doesn't require, they do not need to produce evidence to demonstrate that they have allocated or are able to allocate accommodation within their district. But they must have a policy in place that is to be read in conjunction with the PRSO policy, the offer policy, the allocation policy, sorry. So that when the reviewing officer, or the applicant, the reviewing officer, the court, can look at that policy and say, well, they're taking the steps that are reasonable and necessary to be taken to procure that which is available and offer to homeless applicants. But in the absence of the policy of a procurement policy, how can you measure the discharge of the duty under Section 208? Because there's a veil over the number of properties and what steps are being taken to obtain accommodation that can be used for the selection for a PRSO.
Can we just understand that a bit better? I think you contemplate something that goes into some granular level of detail about, for example, the number of properties secured. I mean, if you took us to page 115, which does state, I can see, key principles of paragraph 2.1, policy to secure accommodation within Waltham Forest wherever reasonably practical. You're effectively referring to the duty.
Yes.
But you must be saying that that's not enough and that you need some further level of detail. I just wanted to...
Yes, there should be more detail, given that when Baroness Hill referred to in the Zoll message, referred to each authority knows the level of need that they need to meet. A procurement policy will identify the need and then how they propose to meet that need. Now, it may be that they are not able to meet the need solely within the district, and if they're not able to meet the need within the district, how then are they going to meet the need? And it obviously will have to be met out of district, as in the case with Waltham Forest, that the district, that Miss Akhter was placed in Harlow. But so we need to see what they offer. There should be a policy that goes further than simply stating, and as it sits in 2.1, that we will seek to secure PRSO, suitable PRSO within Waltham Forest, wherever reasonably practicable. It needs to go, in my submission, a proper procurement policy will go to a further, will set out how they seek to meet particular need. It is right in a, so as a matter of submission, in the absence of that policy and the absence of being able to measure the properties that are available, and when it's going to be, and how how they're being procured and will be procured in the future. In my submission, there is a failure to lawfully discharge this Section 208 duty. It is right in Miss Akhter's case, looking at the specifics, that the authority did identify a list of accommodation that was available, page 41 of the supplementary bundle. And this is a list of accommodation that was available on the 25th of February, which is the date of the offer. And we can see there that there were in particular two properties that were closer, though indeed were closer than Harlow to the district. The offer, the policy, one keeps one's judicial finger in that page and just flicks back to the policy at para 3.6 of page 117. There is a requirement that before an offer is made, a matching exercise will be carried out, taking into account the requirements of the household and the nature and the location of the individual property. The results of the matching exercise will be recorded on the applicant's file. So the policy requires there to be the matching exercise in respect of household and the property that's being offered. But yet there was no such matching exercise.
Wait a minute, this is the temporary accommodation.
No, my Lord, no, this is the PRSO policy, page 117.
So you're saying that policy wasn't adhered to?
Sorry, my lady.
You are saying that that policy of recording...
Yes, it wasn't adhered to.
Well, at least recording the matching exercise was not adhered to.
Yes.
Well, it's your submission that the matching exercise referred to in paragraph 3.6 on page 117 requires the local authority to look at each property available on the list and say why they're less suitable.
It's to match the property to the individual in the context of the available properties, in the context of section 208, and whether or not to discharge the duty closer to home, so to speak. But what my principal submission is that in the absence of a procurement policy, the allocation in and of itself is unbalanced. The two have to walk together hand in hand, so that it's quite clear to an applicant how the duty that under 2.8 is being discharged and what accommodation is being procured and will be procured during the period in question. And therefore, for those reasons, in my submission, section 208 has not been discharged, lawfully discharged in the absence of the procurement policy.
I'm sorry, Mr. Culver, perhaps I'm slow. I simply don't understand that proposition. I understand that you say that the list of 10 available properties included some which were nearer to where Ms. Akhter wanted to be, and you say on the facts reasons should have been given as to why she was being put in one which was not the nearest. That's an allocation decision. I don't understand why the absence of a procurement policy impacts on it, unless you're saying that to have only 10 properties located as these were was so unsatisfactory that the council was in breach of statutory duty.
My Lord, the difficulty is that in the absence of a procurement policy, I'm in the dark as to how the authority are procuring accommodation which is then allocated. And then in the absence of the matching exercise, how this was identified, how this was allocated. So the guidance given by Baroness Hale and the Secretary of State of transparency in decisions and how those decisions are being made in discharge of the duty isn't there in the absence, and we have an imbalance, and in my submission that imbalance is unlawful.
Is another way of putting this that you're saying that the authority has a positive duty to accommodate within the district, if I think the wording is if reasonably practicable.
Yeah.
And you're effectively saying, I think, that they can't discharge that duty without setting out a procurement.
Yes.
But this is an issue raised only in Akhter against Waltham Forest, not in Hajjaj against Westminster.
Because there is a policy in Westminster for
Procurement.
For procurement.
We have it?
You don't have it.
No.
If you're
No, I'm not asking for more documents.
How much detail does Westminster's procurement policy go into?
Westminster, it goes. It is detailed in that it identifies what the need is and how they are going to meet that particular need in the period of time.
So it's an annual exercise, is it? Or?
I don't believe it's an annual exercise. I need to check, but there is a certain life to the policy, and they identify the different sources by which they will secure accommodation to meet the identified need, ranging from renting, private sector leasing, to purchase properties.
you.
Unless I consist of that, of course, those are my submissions.
Right.
Thank you. Well, it's about 8 minutes to 1. Shall we break off there? And then, Mr. Peacock, you can make a clean start at 5 to 2. Thank you very much.